Greetings everyone. Welcome to day 2 of the 9th Asia Pacific ADR Virtual Conference. My name is Sally O and I'm Case Counsel at KCAB International. As your host for 2020, I share our excitement for another day's worth of rich and insightful discussions regarding the new arbitration landscape of 2020 and beyond. We thank you very much for joining us again today. Now, without further ado, we will begin our third session. This session will discuss the current status and progress of reforms in the investor-state dispute settlement and its impact on investment treaty policies. The moderator for this session will be Professor Hi-Taek Shin, Chairman of KCAB International. Professor Shin, when you're ready, please proceed.
Thank you, Sally. Good morning, good afternoon, and good evening, ladies and gentlemen. It's a great privilege and honor for me to moderate this session with eminent speakers today. In recent years, we have seen waves of voices calling for reform of the protection of foreign investment through current investor-state dispute settlement system based on arbitration module from various stakeholders and civil societies, both at national and multilateral level. This session will first review the current status of the ongoing discussion of possible reforms to the investor-state dispute settlement at UNCITRAL Working Group 3 and the prospect for the future. Thereafter, we will hear from experts on whether and how major economies respond to such calls for reform in the investment treaty policies. In this regard, we will review investment treaty policies of the United States of America, European Union, China, and Korea. Finally, Secretary General of ICSID will update us with ICSID efforts to amend its rules and to enact Code of Conduct for arbitrators. We will start with Anna Joubin-Bret, Secretary of UNCITRAL in Vienna. She was deeply involved in investor treaty issues when she worked at UNCTAD for 15 years. She herself sat as an arbitrator in investment arbitration cases before she was appointed as Secretary of UNCITRAL in 2017. Kinnear has been Secretary General of ICSID since 2009, has recently been re-elected as Secretary General for another 6 years. Prior to joining ICSID, she worked at Trade Law Bureau of Canada. Mr. Patrick Pearsall used to work as the Chief of Investment Arbitration at the State Department of the United States of America before he came back to private practice. He is now a partner at Allen & Overy, Washington, D.C. office. I am very grateful to Patrick in that he has graciously agreed to join us live at this odd hour for him. It's 2 a.m. in Washington, D.C. Thank you very much, Patrick. And Professor Malaguti, Maria Chiara Malaguti, is currently serving as the president of UNIDROIT, the International Organization for Unification of Private Law based in Rome. She has been assisting the government of Italy in investment arbitration cases and sat as an arbitrator herself. She has been listed on the ICSID panel of conciliators and arbitrators since 2016. Professor Guiguo Wang is University Professor of Zhejiang University and currently serves as the President of Zhejiang University Academy of International Strategy and Law, Hangzhou, China. He is teaching at Tulane Law School too. He is one of the most well-known international law scholars in China. Ms. Serom Yu is a public prosecutor working at the International Dispute Settlement Division of the Ministry of Justice of Republic of Korea. Currently, she is in charge of defense of treaty-based claims. After we hear all the presentation of the speakers, to the extent time permits, I will pose questions communicated to us from the audience to the speakers. Thank you very much. And Anna, we will first hear from Anna, and the floor is yours.
Thank you very much, Professor Shin. Thank you for having us in this remote panel. Every year, the Seoul ADR Festival is one of the highlights of my year. I'm looking forward to this opportunity to meeting with good old friends, as is the case on this panel. And I greet all my fellow panelists, even the ones who had to wake up so early to join us. It's also an opportunity to catch up with various developments that have taken place in the Asian region and in other regions, and to exchange. So I'm very grateful for the KCAB International to have turned this event into a virtual festival. And I'm therefore very grateful also to be with you and to share with you where we are currently in the UNCITRAL Working Group 3 that has been tasked by the UNCITRAL Commission to reform the investor-state dispute settlement system as we have known it so far for about 60 years. So I would like to share with you that we are trying to move forward in an organized and in a coherent way. And I will do that by sharing with you one of my favorite illustrations of what we're doing that we call jokingly the little house in the prairie, but that has the advantage of showing you that we are working towards something that is coherent and that is based on the existing system, but also very different from the existing system. So I'm going to ask our organizers to kindly put on the next slide. Thank you very much. So usually when you build a house, you don't start from the roof, but I think it's important to flag here that there are fundamental principles that are that everybody has in mind when building this house. One of it is that the states are the masters of their treaties, and that as such, they want to be the ones to keep and to control the treaties, to control their interpretation, and also to control the way these treaties will evolve. And this is why we are in a state-led reform effort in Working Group 3, which is slightly different from what you know, for example, from Working Group 2 on dispute resolution, where the discussion is mainly led and contributed to by experts. Here we have state delegations, and we have many state delegations. Every working group has about 104, 106, sometimes 110 state delegations participating, and participating actively in the sense that all the different elements that I will be showing you of the little house and of the floor plan of this little house are actually based on submissions and proposals made by states to reform the existing ISDS system. The second element, which is closely related, of course, to state control, is that there are existing treaty interpretation tools. We all know and are familiar with the Vienna Treaty on treaties. And one of the things that is missing so far in many investment treaties are also the means to allow the contracting states of these treaties to intervene and to give their thoughts and views about treaty interpretation. So this is an element that we will be looking at in due time, because we have so many other aspects that we have to discuss. Treaty interpretation has been discussed in the last session of the working group in September of this year. And it is indeed one of the aspects of reform that we will be working on. And last but not least, that is also in the roof of this little house, are the substantive standards, the substantive protection standards, on which we are not working so far. And I'm saying so far because the line between substantive standards and procedural standards, as you can all imagine, is very thin for some of them. And we are always mindful that the mandate is a mandate to reform procedure, but we very often see how closely it comes to substantive standards as well. So that's why I've kept it in the roof as one of the things that is overarching, is that it has, the system that is being set up has to be coherent with the substantive standards and has to deliver dispute settlement mechanisms that apply and that are, as I said, coherent and consistent with the substantive standards that are at stake. So now we can enter through one of the doors of the ISDS system, and this one is the existing one. So we have investment arbitration that has been the main entry door into ISDS so far, and this will be remaining. Many states are wish to have to retain investment arbitration as the means to settle investment disputes, whether through the ICSID mechanism, the ICSID convention, the ICSID rules, and or the UNCITRAL rules that are also used for ISDS cases. But we also have another door that we are now going to start building. And this is based on a proposal made by the European Union to set up a first instance and an appellate mechanism. And here we are going to start building this part of the reform that will be optional, of course. Not every state is going to sign on to a first instance investment court. And I'm sure that Maria Chiara Malaguti will give you more about this investment court. But what is important is that it will become part of the broader construct of ISDS reform. And we will begin looking at this, the architecture of this first instance court in the course of year 2021. And two other doors that will remain available for cases to be brought are, of course, the domestic courts that are favored by several countries, including in the region, for example, India or Indonesia, and state-to-state procedures, which are favored by countries such as Brazil, that does not agree with investor-to-state direct settlement, but in its investment treaties provides for state-to-state procedures. So what is going to be very new, and here I would like our colleagues in Seoul to click on the next part of the animated slide, and here it comes, is an appellate level. And here what we are going to be building, and because it has been very clearly put on the front burner by numerous delegations, is the setting up of a standing appellate body or an appellate mechanism, which will work for those who want to go through the door of the first instance investment court as a second instance investment court, and for those who want to continue to enter through the door of investment arbitration, will work as an appeal mechanism, we have already looked into this appeal for both investment arbitration and first instance investment court dispute settlement. And we will be now entering into the actual design phase in the next session of the working group, which will take place next year. And we will start now with the institutional discussions surrounding this appellate mechanism and appellate level. And of course, what we have to take care very carefully about is how this is going to work with the ICSID convention mechanism, which is currently, as you know, not susceptible of an appeal. And of course, we will have to look at one of the proposals that was made, that it would also work as an appeal mechanism for state-to-state procedures. This is one of the proposals that was made by a couple of states, and we will have to look into how we can weave this in to the appellate mechanism level. Now, two wings to this little house that are also going to be developed. One is to strengthen dispute prevention policies, and also to set up an advisory center for developing countries to help them in the defense of their cases. It's not yet clear what the exact scope of this advisory center will be. States have asked that it gets involved in the cases themselves to help them defend the cases, just as the appellate system of the WTO does. But this has to be clarified, and we are finalizing our working paper on this advisory center and on the financing of this advisory center, which is of course the crux of the matter. And on the other side of the little house, you will see the strengthening of the ADR entry door through investor-state mediation. And for this, I invite you to attend next week's pre-intersessional meeting that is hosted by Hong Kong SAR to discuss investor-to-state mediation as one of the reform options. You see the ombudsperson, which is one of the features of Korea's investment promotion and protection system that seems to get a lot of interest and traction from other states, and in general, the strengthening of ADR. So this is what I would say the construct of this reform looks like. And if you bring me to the next slide, you will see a floor plan, which will include all the procedural reform options that are being discussed, and that we are now moving to the stage of model provisions for a multilateral treaty that will encompass all this reform. So very briefly, because there's no need to go into the details, we have started looking into third-party funding, a code of conduct that we're developing jointly with ICSID, possibilities for the states to bring counterclaims, selection and appointment of tribunal members, and also of court adjudicators, means to address frivolous claims, the use of denial of benefits provisions to bring in all these reform options into treaties, security for costs, reflective loss, damages, multiple proceedings. So all of these elements are going to be part of a multilateral treaty. And what this multilateral treaty will bring is the possibility for all these new provisions to apply also to the existing 3,000 plus treaties. And the mechanism is quite easy to understand. It will work like the Mauritius Convention. When two states are parties to this treaty, the provisions of this treaty will supersede the existing bilateral investment treaty between these two states. And we are also looking into the way to bring the earlier construct of the little house under this multilateral investment treaty, and to allow states in a very flexible manner to pick and choose from the different options and to decide what the reform option they wish to use for their existing investment treaties and future treaties, of course. So this is really what I wanted to share with you. We have made a lot of progress in the last year and a half. In spite of us having to work remotely, we managed to advance on all the reform options that we have on the table, except for damages that is still to be discussed, but otherwise all reform options have been discussed at least once. And we have now clear guidance from the working group on how to design and to prepare the reform option that fits into the broader, under the broader roof of investor-state dispute settlement. This is what I wanted to share with you, and I'm of course available for any questions you may have about how to build a house and also how you can help us build this house to make it very solid and founded on stone. Thank you very much.
Thank you, Anna, for the very concise explanation of the very comprehensive and ambitious project. Because due to the constraint of time, we will move to treaty policies, and then if time permits, we could come back with questions. There is already one question, but I will defer it to the end of the session. Thank you very much. Then next, we will hear from Patrick Pearsall. And as I said earlier, he is in Washington, D.C. and at this 2 a.m. in the very early in the morning. Thank you, Patrick, for your willingness to join us live. Patrick?
Well, good morning, and good afternoon, everyone. I'm not sure if you can see me at present, but I'll start my video. There we go. And I hope you can see what I'm projecting. It's been a long couple days here in Washington, but it's great to be in Seoul virtually and with colleagues from all around the world. So thank you to the organizers and to our hosts at KCAB International, and to my fellow panelists, and to you, our audience, for choosing to spend this session with us. I don't think anyone slept here in Washington for several days now, so it feels perfectly natural to be up at 2 in the morning. My brief remarks from Anna's house to the White House, I guess. My brief remarks will focus on this dynamic and moment in which we find ourselves. And with the result of the election nearly announced, and given the status of the election currently, I thought it would make sense to speak a little bit about what the future may hold for investment arbitration from the perspective of the United States if former Vice President Biden were to win the presidential election today. And I'm going to do it through the lens which I'm going to call local multilateralism. So let me first begin with setting the stage. Many lifetimes ago, it seems, in October 2016, ISDS reform was considered needed. It was discussed at the IBA conference, for example, in Washington as being needed, but very unlikely. And the concern was that if we started to reform ISDS, that it may result in unnecessary and unwanted changes to commercial arbitration. And I think investment protection is understood by most states as necessary. They understand its importance. And I want to start by situating investment arbitration in what was always understood as a multilateral framework. Geopolitically, states that trade with one another and states that share investments are far less likely to engage in armed conflict. Peace, security, they really do in large part depend on trade and investment. And it's why I worked at the US State Department And it's why many states still seat their investment treaty lawyers and trade negotiators within foreign ministries. And while treaties are often bilateral, many more investment agreements are contained within multilateral instruments currently. And of course, the ICSID provides a large multilateral framework for the enforcement of awards. And in October 2016, we didn't really, here's a multilateral view of kind of how interconnected we are at this point. And in 2016, we didn't really yet know the extent of how unilateral and inward looking the world would soon become. So you had this moment where folks were starting to understand that reform of ISDS was necessary, and it was parallel to this moment where we were entering a far more inward and unilateral looking moment in our history. And with the election of Trump, America started to retreat into its most isolationist period since the 1940s, including with specific reference to 1940s slogans like America First. And for the past 4 years, the United States has not had a clear position on investment arbitration reform. Trump's America First bilateral agenda does not nicely fit within a rule of law based system of peaceful international dispute resolution. Similarly, Trump took the United States out of multilateral institutions. Here's leaving climate change, threatening the United States participation in NATO, favoring instead hard American power to the exclusion of traditional alliances. So now, with a person who spent their entire career building diplomatic alliances and who understands America's place in the world through a multilateral lens, about to perhaps win the presidency, former Vice President Biden, how will he, if he wins, and consequently the United States, approach investment arbitration? And in general, I think we will see a major shift towards what I call multilateral re-engagement. But that shift will not be toward multilateralism as it was understood in a pre-2016 notion, this cosmopolitan multilateralism. Instead, I think what President-elect, if he is President-elect Biden, will bring America back to doing is being in dialogue with multilateral institutions like the United Nations, like the WHO, like the Paris Climate Framework, perhaps even the WTO itself, but will do so with a clear-eyed understanding about how multilateral globalism must include what I would call local sensitivity. So I've decided to call this local multilateralism. And what I mean by it and how it relates to investment arbitration will become clear as I continue. But it's an approach to multilateral re-engagement that's grounded in how the domestic populace will benefit or not from multilateral frameworks. Trade agreements, yes, but trade agreements that include front and center the direct impacts on local people, right? Labor, environment, it's the macro and the micro all at once. And I think that's what you can expect from a Biden vision of multilateralism. So what does this mean for ISDS reform? Well, it depends, in my view. How states will treat foreign direct investment in a world where the largest economies are fighting for influence over smaller economies, all in an effort, it seems, to influence the social fabric of those societies. That will be the defining question. What is the impact on local people? So I think the United States under a Biden administration will be re-asking the fundamental and foundational questions about the Washington Consensus and investment arbitration. ISDS, in my view, is a dispute resolution system that is meant to help keep us safe from the destructive nationalist winds. Policymakers, in my view, need to better understand the public international law foundations of ISDS, which are sometimes multilateral. And we need to kind of resist the gunboat diplomacy that marks a kind of nationalist vision. But ISDS is a system that is both progressive and free market. And that's very similar to what former Vice President Biden has spent his career doing. So he was in favor, as you see on the slide there, he was in favor of the TPP. He was in favor of NAFTA. He was in favor of normalizing trade with China, all with a concern about how these multilateral relationships would impact progressive ideals like labor and environment, what I would call a local multilateralism. And I think the local multilateralist approach is how a Biden administration will approach the Pacific. Whether we rejoin TPP or CPTPP, and I was one of its negotiators, so I my views on that are pretty obvious. How we will approach trade and investment policy in North America or with China, all of these are questions that will be defined first by how participation will impact real people on a local level. Again, labor, environment, jobs, training. This is the Biden 21st century Building Back Better plan. And similarly, local multilateralism will need to react to the isolation of the United States from its America First period. How do we re-engage in Europe, for example, with the United Kingdom after Brexit? There's a trade and investment negotiation underway currently. How do we re-engage with the European Union? Again, a trade and investment agreement is underway currently, and our largest trading partner, Canada, has already enacted one, right? CETA. And finally, how do we re-engage with a regional and multilateral security agency to ensure that liberal democracies are able to flourish and trade and investment is able to bring the benefits of development to all people? So what does this local multilateralism mean for what Anna and others are building at UNCITRAL? I don't know. I think there's a genuine desire for the United States to be part of a multilateral framework under a Biden administration. And I think the investment protection system, large regional trade agreements, and even proposed investment courts are all clearly strong multilateral institutions. However, this is not the pre-2016 multilateralism. This is local multilateralism. And the question that will need to be answered with the satisfaction of a Biden administration policymaker will be, how does investment arbitration help people? How does investment arbitration help people? What are the benefits to people? And what are the drawbacks? And it's the macro through the micro. And here is the clearest statement former Vice President Biden has said on ISDS. He says it's a process that he opposes in the inclusion for future trade agreements, right? And again, one of the leading ISDS critics in the United States, Senator Elizabeth Warren, she has a good deal of influence on the Democratic Party, and she is staunchly opposed to ISDS. So here, in the waning minute or two that I have, here's the kind of things to watch in the first 100 days of a Biden administration. Re-engagement, what re-engagement looks like. Look for the first trip to Europe, look for the first trip to the Pacific to see where a Biden president goes. Look to see if things that I worked on when I was in government are re-engaged, the US-China bilateral investment treaty, the US-EU bilateral trade talks, see how those move forward. And then think about how trade and investment plays into a national security priority statement, which will be issued in the first 100 days. And the people to watch in the United States are who a President-elect Biden puts in the US Trade Representative's office, who becomes the Undersecretary of State for Economic Growth and Energy and Environment. That's the key position at the US State Department other than the Secretary of State. Who the ambassador to China is, who the ambassador to the UN is, who the assistant to the president for economic policy, and who the National Economic Council directors are. All of those people, whomever they are, will affect US policy on this. And finally, I just want to say that we don't know what kind of re-engagement we will see from a Biden administration if he is certified, if he does win the election. And I think it's been a long and isolating 4 years for the United States. And in my view, 2021 will be different. And I'm reminded of the great Korean poet Midang's famous line from Beside a Chrysanthemum. And I'm not going to say it in the Korean, but I think I have a good translation. Midang writes, "Last night's frost came down to bid your yellow petals bloom, perhaps." And that perhaps is just so devastating, but it's also so very hopeful. And today at 2:30 in the morning in Washington, D.C., I'm very hopeful. Thank you.
Thank you very much, Patrick. We are very fortunate to be the first to hear the investment policy outlook of new administration from an expert based in Washington, D.C. I think it's very, very insightful, and thank you very much. Then we will move to European Union, and we will hear the EU investment policies and development from Professor Maria Chiara Malaguti. Professor, please.
Thanks a lot. I heard so interesting things until now that it's difficult for me to speak of the European Union because I would just go and discuss what I heard until now. I have very few minutes to tell you many things, so I will try to focus on the main messages, which I think I can give you, and then if you are interested, you can see more articulation in the slides that I have provided. It is here the real. Let me just start the presentation, so it's gonna be quicker. It is in fact I think that in order to understand Europe and the policies in Europe, we cannot just go directly to what Europe is elaborating on a multilateral investment court. This is, of course, the focus I see of our discussions, but I think we would much better understand what's going on if we take a look also to other legs, let's say, of the same foundation. These three layers are all connected, and I would, if I could summarize the approach of Europe right now, I would say a paradigm shift that occurs at all levels, internally inside the Union, in our FTA, so in our agreement with commercial partners, and finally in the proposal that the European Union is making within UNCITRAL and in general in all our international discussions. So let me go quickly to the first part, the issue of rules, or better, new rules for investment protection inside the Union. I do not want to discuss, I cannot, in fact, being an arbitrator myself, I cannot discuss the issue of ACMEA, and I don't think it's really the point today in this discussion. But what is interesting is, in the first place, Patrick said that the story started in 2016 for the US, for some debate in the US. For us, the story started much before that, because in fact, we all focus on Europe basically after ACMEA, because the decision on ACMEA, which says, for those who are not familiar with this, the ACMEA decision is a decision of the European Court of Justice, and it says that ISDS cannot be used inside Europe, the European Union, at least for bilateral investment treaties. So the ACMEA decision was focusing specifically on one bilateral treaty, and part of the debate is whether this decision can also apply to multilateral treaties like the ECT. On 29 of October, we had a legal opinion of Advocate General of the European Court on another case. An Advocate General in the European system is a sort of amicus curiae. Its opinion is not binding to the court, but it has quite a sort of moral suasion. In that opinion, so 29 October, you find a paragraph say that in his understanding, this decision should also apply to multilateral treaties. But what is relevant is that the story did not start with ACMEA, but it goes back 10 years before, when the Lisbon Treaty was adopted. The Lisbon Treaty is one of the European treaties. We started with the foundation, the Rome treaties, back in the 50s, and then the upgrading of the European Union took finally to Lisbon Treaty, where the competence of direct investment was moved to the European Union. So it was centralized. We had already a centralized trade policy, but not the direct investment policy. That was kept by member states, now was moved to the European Union. The story started at that time. And from that time, we really started discussing a paradigm shift. What is important is that ACMEA talked to a treaty, which is a termination treaty in May 2020, that obliges all member states to terminate the BIT. And it links with a communication that was adopted by the Commission in 2019, where they try to propose alternative ways. So what is interesting is that in the Commission Working Programme 2020, there is a proposal for alternative ways of settling arbitration disputes inside Europe. Why I'm telling you this? I'm telling you this because this is really part of European policy. As you can see from the slides that you have in front of you, some of the choices that we are discussing today in Europe are similar to those that are taken at the international level. So the possible alternatives are either to leave the competence to domestic authority, to domestic courts, and somehow get rid of the structure of ISDS inside Europe, or creating an ombudsman-like administrative body. And Anna already mentioned this as one of the options that we have on the table, not as the single option at the international level. Then to create a specialized investment court also inside Europe, modeled on another one that we have on the patent court, which a unified patent court, which is a specific court that we have in Europe. And finally, to have prevention mechanisms. So it's the policy logic in Europe is internally, we do not go for this instrument, but we try to build a single capital market union and a single market where there is no need for the kind of instrument. But what's happening outside, because one of the debates was, so Europe does not want ISDS any longer. I would say that in respect of what Patrick said, is that we, on the opposite, do strongly believe into multilateralism. In fact, I think that if you have to compare, I mean, whatever it is, I would say that all proposals of Europe go into the direction of strengthening multilateralism also in the investment sector. So strengthening and better coordinating the policy inside Europe with other instruments, and working on a paradigm shift at international level for the solution of disputes. You are all familiar with the fact that the European Union has a number of free trade agreements where in all of them we are proposing an investment court system. You see that the first one was Vietnam. Then we had the CETA that was already mentioned, which is the one from which we built on the proposal of an international investment court. Then Singapore, then very recently Mexico. While with Japan, we are still in negotiation for time being. There is only an EPA that was adopted and nothing on dispute settlement. But in all these cases, the European Union is proposing a court, an investment court that would solve all possible cases that you have inside for that specific treaty. So getting rid of the current ISDS system and using a court. But again, I would not keep the issue of the independent investment court system detached from the rest, from the substantive rules, because in these agreements, you also find a number of rules that are quite innovative and probably what now called the third generation investment agreements, also on right to regulate, on sustainable development, on responsibility of investors inside the host country. So it is a package, I would say, where you also have an independent investment court. But what's happening now? Patrick was speaking of local multilateralism and indeed the multilateral model. Also, the European Union has a sort of multilateral model. But what is interesting, in my understanding, is that what you have now are a number of agreements where you have these same principles, which could be multilateral in nature, but which are applied in a fragmented way regionally. CETA applies only with Canada, then you have the one with Vietnam, the one with Mexico. So these same standards, but not applied under the traditional multilateral approach. So how can you somehow try to make this harmonized or more logic? And here it's where the proposal for an international court comes, which is if we start having a more harmonized set of standards for each block, we can even start considering to have a general understanding. This general understanding would be that the general understanding would be applied and interpreted and applied also with the effort and the use of an international court. So the logic is we try to make sense of investment law today through judiciary, well, I mean, through the, of course, the authentic interpretation of treaties by states. This will never change, on the opposite. And Anna already told us this is one of the main issues on the table. But also, you know, we try to make all the case law consistent and try, you know, to get into a new multilateralism one way or the other. Before getting to in the last minutes I have on the proposal for on the International Investment Court, I would say that of course we are also working on how to establish the details of the organization of the ICS with Canada, and again also in the European proposal you find exactly the same kind of features. that are also proposed for the ECT. But let me go extremely quickly to my last point. We presented two notes on the at UNCITRAL, and this is the main slide on that, which is what we propose is indeed investment court, a multilateral investment court, which would be quite articulated. The debate that is coming out is extremely interesting, in my understanding, on a two-tier body, first instance and appeal, with a permanent body of decision, and working on so trying somehow to repeat models. We are still discussing which one inside UNCITRAL. As Anna said, we are at the very beginning of discussion, but the WTO mechanism is one of the possible benchmarks. But in any event, the possibility also for both parties to start the proceeding and get into appeal, and try little by little to open this mechanism to everyone. Of course, we have many by BIT, so it's going to be extremely difficult to do this exercise, but Europe is really trying to get into that. So to conclude, what is the position? For sure, a paradigm shift in ISDS, a paradigm shift that would take to a different kind of multilateralism, but which does so. I agree that also for Europe, the original multilateralism for investment is probably not the solution any longer, but with these same principles, and also taking into consideration that all protection tools need to be read together with the responsibilities by investors on sustainability and by conditionality. So it's a paradigm shift that also includes the debate on the role of investors in the market. I'm sorry for having been so quick in saying so many things, and thank you really for this opportunity.
Thank you, Professor Malaguti. It was really very effective presentation on the very comprehensive paradigm shift. It's very helpful in understanding the EU's position, especially in the context of Working Group 3 discussion. Thank you very much. Then we move to China. Professor Wang, the floor is yours. Professor Wang?
Yes, I'm here. Thank you very much. Can you hear me? Come. Yes. Well, thank you, Hi-Taek, and also I'm very pleased to see so many friends here, including Anna, and I will do the presentation now, and then I hope I can share this. As many of you know, that China actually started its opening policy in the early 1980s. Over the last 40 years, China has entered into 145 BITs plus 21 FTAs. It is certain that China has benefited a lot from foreign direct investment. As many of you may not remember, in the early 1980s, China was number 14 in GDP in the world, while today, as many of you know, of course, is the number 2. Without foreign investment, I would say that China's economy could not ever has grown so fast. With regard to China's policy toward ISDS, roughly speaking, it has gone through 5 stages. when China first started its BIT, that was with Sweden. In that BIT, there was only 9 articles, nothing mentioned at all with regard to ISDS. The two countries had an exchange of notes, simply saying that in future, if there is any change of policy, Sweden should benefit from it as well. Then in 1984, in the Belgium-Luxembourg BIT, amicable settlement was mentioned. Also, China emphasized on the use of domestic jurisdictions, and they made the use of international arbitration only as an exception. Then in 1985, I would say this is the second stage with the Singapore BIT. The reason why I say so because in addition to amicable settlement, the local court procedures, it was for the first time that China committed itself to international arbitration. But this arbitration was only available for disputes involving the amount of compensation resulting from expropriation. And this policy lasted almost for another 15 years. And a very well-known case, Shin case, I think versus Chile, as you know, the tribunal explained and ruled on this provision. In it, I think another point is they made a reference to ICSID convention. Also, they say that in case the two parties cannot have an agreement on the third arbitrator, the third arbitrator should be appointed by the chairman of the Stockholm Chamber of Commerce arbitration. And then another BIT followed is China-Korea BIT. For that one, most of the provisions are quite similar to Singapore one, except national treatment, most favored nation treatment were mentioned in the BIT with regard to dispute resolution. Also, the two countries agreed that in case the third part arbitrator cannot be agreed upon by the two disputing parties, that arbitrator should be appointed through a method agreed upon in advance. I think that somewhat showed Asian nature or Asian preference for such a dispute resolution. Then a real modern, I would say, provision with regard to ISDS came in 2001 with China and Cyprus signed the BIT. That year, as many of you know, China joined the WTO, and also several years earlier, China signed the signed the ICSID convention, and therefore, at the turn of the century, China was quite comfortable with using ICSID and also using ad hoc arbitration for the settlement of investment disputes. Still, even in Cyprus BIT, they made it clear that in case local laws require the settlement of such disputes within the country, then it has to be settled with, has to use the local code. Also a fork in the road provision stated in China-German BIT followed more or less the same standard. And then in Canada, this China-Canada BIT, that is the most complicated BIT China ever signed with a foreign country. For itself, it has 35 articles, plus number of annexes. It permitted investors to submit disputes to ICSID and also to UNCITRAL arbitration rules. And it can also stipulated in separate articles, such as consolidation, non-disputing contracting party, right, public access to hearing, and so forth. I would say this is the most comprehensive, and also it is quite followed by some other BITs. Governing law, for the first time, Canada BIT agreed to be bound by the BIT as well as international law. And then the current stage, I would say, starting from the trilateral BIT with China, Korea, Japan, to exclude using IMF for dispute resolution. Also in China-Australia FTA, the investment chapter approves the use of the establishment of an appeal procedure with regard to dispute resolution. The most recent move by China is the setting up of the International Commercial Dispute Prevention and Settlement Organization, which took place on the 15th of last month. This organization was set up with the help of institutions of more than 30 countries. Incidentally, I was involved in the drafting of the set of rules that this organization was going to use. Briefly speaking, this organization will emphasize on the good offices to deal with investors' complaints. It's similar like a prevention or control management mechanisms. In some of the provinces in China are already using this. Mediation will be emphasized, and it was very much emphasized in the rules with regard to commercial arbitration, commercial disputes, investor-state disputes. Also, appeal procedure was proposed in the rules, and these appeal procedures will deal with investor-state arbitration as well as state-to-state arbitration or dispute resolution. Third-party funding is also emphasized in these rules. And last but not the least, I want to say that these rules were drafted with the help of a group of experts from more than 10 countries, and now wide consultation are being sought to improve the draft, and we hope that this organization will have genuine international participation, will be open to all the interested parties, and that will be China's contribution to the world. Thank you very much.
Thank you, Professor Wang, for giving a bird's eye view on evolution of Chinese investment treaty policies over the last 40 years. Many of us are envying you as you seem to be sitting on the beach and this time of the year season. We really want to be on the beach with warm breezes. Thank you very much. Then we will go to Ms. Serom Yu, presenting on the Korean investment treaty policies. Prosecutor Yu, please.
Hello. Hello to all. My name is Sarah New, and I'm humbled to be here today as a speaker. And I extend my gratitude to Professor Shin for moderating this session and to other participants of this conference. Today, I will be speaking about Korea's investment treaty policies. I will first give a brief overview, and I will touch upon Korea's participation in the ISDS reform discussions and relevant developments in Korea and dispute prevention effort. Please note opinions or views expressed here are my own, not Korean government. Korea is one of many countries with active investment treaty practices around the world. Throughout the 60s and 70s, Korea signed many BITs, mainly with developed countries in Europe for investor import. Korea's investment treaties negotiated with developing countries from the mid-70s and onwards fosters Korean investors to invest abroad. After the 90s, Korea negotiated treaties both as an investor importer and exporter. In the 90s, more than 30 BITs entered into force. So far, Korea has 9 bilateral investment treaties in force and 7 signed. There are 16 FTAs in force, most of which contain an investment chapter. Korea, both as a capital importer and exporter, continues to negotiate investment treaties with the aim of striking the right balance between providing adequate investment protection for investors and preventing the abusive use of ISDS. For treaty negotiations, Korea strives to read international investment treaty trends and adjust its treaties in a way to reflect recent developments in the ISDS regime. For example, the amended Chorus FTA incorporates provisions that address frivolous claims. The amended treaty inserts a language that allows tribunals to address claims that are manifestly without legal merit. Such an amendment is also consistent with other treaty developments, such as comprehensive and progressive agreement for Trans-Pacific Partnership. The amended Chorus FTA is commended for it being the first treaty in Korea that provides somewhat of a framework to address frivolous claims. At the same time, Korea closely monitors any developments in the ISDS regime and has been actively participating in the ISDS reform discussions. Particularly in the context of UNCITRAL and ICSID. First, at UNCITRAL, Korea has joined the collective efforts of the member states participating in the Working Group 3 in identifying concerns over the ISDS mechanism. Korea submitted its country submission last year, proposing to discuss regulation of third-party funding, international cooperation on investment dispute prevention, and regulation of claims by multinational hedge funds. Next. As part of the exit rule amendment, Korea jointly submitted comments on the content of the request for arbitration, notice of third-party funder, decision on costs and security for costs. Korea also separately submitted individual comments on the rules concerning procedural language, translation and interpretation, security liability for costs and submission of non-disputing parties. As much as dispute settlement is important, I believe dispute mitigation through the use of ADR can be very helpful to avoid or reduce ISDS claims. ADR, including mediation, is another area that Korea has adopted in treaties. Most of Korea's investment treaties insofar contain ADR provisions, including consultation, mediation, conciliation, or negotiation. ADR has been actively used in practice, most commonly consultation. There have been cases involving Korea where disputes ceased to proceed after consultation, or where the dispute settled through domestic mediation after going through a consultation. Therefore, effective utilization of ADR or mediation would be an important tool, especially with the Singapore Convention on Mediation that just entered into force. Also, dispute prevention is important. The Ministry of Justice hosts a series of investment prevention training sessions for various governments and agencies. The training covers what ISDS is and what may constitute a violation of the state's obligation under treaties. Another practice is the Foreign Investment Ombudsman Office of the Korea Trade Investment Promotion Agency. The Ombudsman is dedicated to investment support and aftercare services. It works with government officers as well as home doctors that are experts in investment-related areas like finance, taxation, labor, and environment. Grievance support services are provided at no charge, and every complaint received remains confidential. This chart shows that the number of cases has increased significantly recently. The Ombudsman practice is widely referenced as a model practice for investment aftercare. On closing, I believe striking a balance between investor protection and prevention of ISDS abuse is crucial when negotiating investment treaties, and the use of various tools and resources, including ADR or dispute prevention, would add a value. Hope this gave some insight into Korea's investment treaty policy. Thank you for your attention.
Thank you, Mr. Yu, for sharing us overview of Korean investment treaty policies and also dispute prevention measures. Thank you very much. It was very helpful to understand. Then we will have our last speaker, Meg Kinnear from ICSID on ICSID development and update.
Good afternoon. I'd like to start by thanking the organizers for this opportunity to present to you about what's been happening at ICSID in the last year and in investment arbitration more generally. It's been an extraordinarily busy and, of course, at times challenging year for ICSID. In the previous session, I gave an update on how ICSID has adapted to the COVID pandemic, and in particular, the shift to electronic filing and to virtual or remote hearings. As a result, I won't cover that material in this session, except to reiterate that we've made tremendous progress and that we've seen tremendous benefits from this technology. Over the last 6 months, we've held more than 100 virtual hearings and sessions, and the technology is certainly up to the task, and all of us involved in these, arbitrators, counsel, and secretariat staff, have seen real benefits in terms of time and cost saving. With respect to trends in the ICSID caseload, the headline statistics have been relatively stable in recent years. So for example, last year, ICSID administered 303 cases, just slightly down from the record 306 administered in the prior year. Highlights include the fact that 68 cases were concluded, which is a record for us. I think this is an important record because it shows that all of our efforts at improving efficiency are paying off and we're able to conclude cases more quickly. We also saw progress in the diversity of arbitrators, conciliators, and committee members in terms of their nationality. Last year, individuals of 44 different nationalities were appointed in ICSID cases. And I should note that many of them were from Korea and from Asia more generally. This is the greatest nationality diversity in arbitrator appointments that we've seen in a single year at ICSID, again showing that our efforts are reaping a benefit. These statistics and other statistics along this line are all available in our recently released annual report and in our caseload statistic reports. So I'd encourage you to take a look at those if you want some of that kind of information. I wanted to take the remainder of my time today to update you on 2 key projects currently underway at ICSID. The first is the amendment to ICSID's Rules of Procedure, and the second is the Code of Conduct for Adjudicators in Investor-State Disputes, something that we're working with the UNCITRAL Secretariat on. So let me start with the status of the ICSID rule amendments. As a lot of you are aware, this is a process that began in 2017 and which has advanced considerably since then. ICSID has published 4 working papers with proposed amendments to its procedural rules for arbitration, conciliation, and fact-finding. And we've drafted an entirely new set of rules for investor-state mediation. The process has been by far the most transparent and inclusive in our history, with us inviting public input on the proposals, which has then been published on the ICSID website. We've also held well over 100 briefings around the world with the full range of stakeholders. In terms of the most recent developments, Working Paper 4 was issued in February 2020, and a 4th in-person consultation with state representatives was scheduled for April 2020. And in fact, we expected that that might be the last consultation and would enable us to then put a set of rules to a vote by our member states. Unfortunately, this had to be postponed due to COVID, but we still remain within striking distance of consensus on the rule amendments. So the key thing has been in the last several months to maintain the momentum and to try and gain consensus on those few outstanding issues that seem to require more dialogue. To that end, we asked states to even further comment by July 31, and we've published those comments on the website. We're now working on a 5th working paper that will be released in the spring, and we hope that further consultation, either virtually or in person, will allow us to be in a position to table a final package of amendments for approval by member states before the end of next year. In terms of the amendments themselves, just looking at the size of the working papers will probably signal to you how extensive they are. And in fact, a number of them touch on some very topical issues in investor state, so they deserved a lot of conversation and a lot of thought into how we could deal with them. The number one topic, of course, was reducing time and cost, and that's a difficult problem to solve. We studied where delay occurs, and it is not just in one part of the process. In fact, delay in many cases is idiosyncratic. Interestingly, during the comment phase and the consultation phase, we heard a lot of parties say that they needed more time. So the places for reducing time are not always evident. What we came up with was basically a multi-track approach. In other words, save time wherever you can throughout the process. So we started with a general duty of expedition on arbitrators and parties. as well as a number of specific times for certain phases, one of those being delivery of decisions, orders, and awards. Compliance with those timelines is going to be tracked on the ICSID website, giving parties more information when they make decisions about party appointment of arbitrators. We also designed an expedited arbitration process that parties can opt into, and if followed as prescribed, it would lead to a result in roughly half the time of the current average case, of course also reducing cost. A next very contentious issue was third-party funding, where there are a huge number of opinions, many of them irreconcilable. Our approach was to focus on that set of opinions where I think there is consensus, and that was with respect to disclosure of the existence of third-party funding and disclosure of the name of the funder at the earliest possible moment. So the rules require disclosure of the funder right after the request for arbitration has been registered. And the obligation to keep that information current continues throughout the duration of the case. And the result of that, of course, is to avoid any kind of inadvertent conflict of interest between an arbitrator and a third-party funder. Another very debated issue has been security for costs. The new rules propose a specific provision on security for costs, and it specifies the conditions for adding a security for costs order. It makes it very clear that security for costs should not be automatic, and it notes in particular that third-party funding, while it may be evidence going to the relevant criteria, is not in and of itself a basis for ordering security for costs. We also heard some concern about third-party funding leading to frivolous claims, but again, in the ICSID context, we already have a rule that deals with manifest lack of legal merit, so that did not have to be addressed in this rule amendment process. The next topic was increased transparency, taking somewhat of an inspiration from the Mauritius Convention and the impetus of many states to increase transparency. In our ICSID rules, the proposal was especially to focus on publication of awards and decisions, which can help ensure more consistent jurisprudence, something that we hear in a lot of the reform discussions. We also added an interesting provision dealing with confidential and protected information and trying to define more specifically when information would be dealt with as confidential. So that in many ways complements the increased transparency of the whole process. Finally, we have looked at and offered new mechanisms for investor-state dispute settlement. And the idea here is that there should be a choice of dispute settlement options, not only to have one or the other, but also that these sometimes can mutually reinforce one another. And in particular, we heard discussion about having, for example, an arbitration, but perhaps in parallel or with a stay of proceedings, mediating one of the issues in the dispute and making the arbitration more simple. So there are a lot of ways that these can be used, and we wanted to provide these tools to parties. So we have provided a new set of mediation rules specifically developed for international investment disputes. We significantly revised the ICSID fact-finding rules, making them more simple and more streamlined, and we revised the conciliation rules to make them much more flexible, typical ADR tools. I should also note that on choice, ICSID will continue to offer administration of UNCITRAL and ad hoc cases, and this, of course, is not only a good in and of itself, but it also allows counsel to more easily consolidate or coordinate a fact situation where there might be, for example, an UNCITRAL case and an ICSID case, and to reap the time and cost benefits from having those heard in one place and together. So those are some of the things that are still being worked on in the amendment process and that I think should come to a resolution soon, and hopefully we will be able to have a new set of rules in place towards the end of this year or early next year. Finally, I wanted to give you a brief update on the Code of Conduct. As I noted, we are jointly drafting this with ICSID and UNCITRAL secretariats, and it's meant to be generally applicable to adjudicators in investor-state cases. It includes general principles in the Code of Conduct, the usual ones you would think, obviously dealing with impartiality and independence, but also specific provisions on issues such as double hatting and repeat appointments. A first draft was published in May of this year. And in developing that, we did a very extensive review of the standards found in codes of conduct in investment treaties, in arbitration rules applicable to investor state, and in the codes of conduct of other international courts. We also did an extensive review of the case law to date. We have discussed this draft extensively with state representatives, arbitrators, counsel, and other stakeholders. And currently, we've invited written comments to be submitted before November 30th of 2020, so that we can take these, try to incorporate as many as possible into a revised draft, and then speak to stakeholders and see, again, through an iterative process, if we can come to an agreed upon code of conduct for investor state dispute settlement. If you've not looked at these or not commented on them, I would definitely encourage you to read them and to send us any comments that you have. We are clearly at an early stage with some difficult issues, and your participation would be most welcome and most appreciated. Finally, if you have any questions on the rule amendments or the code of conduct or any other ICSID matter, please do not hesitate to reach out to me. And that leaves simply for me to tell you that I appreciate your time this afternoon, and that I hope that we'll be able to meet in person in the next year. Have a good afternoon.
Thank you very much, Meg. It was also, again, very comprehensive subject delivered in a very succinct and clear way. We learned a lot on the current development at ICSID. Unfortunately, due to time constraint, I regret that we may not have time to do the Q&A from the audiences. I will discuss with the organizers so that an answer could be delivered in due course to the one who raised the questions. So I think we need to conclude our session now. I find that all the presentations were very informative and insightful and stimulating. The only regret is that we have very limited time. And would you join me to thank all our speakers for their excellent presentation? And I also thank you for the keen attention to this session. I will discuss with the speakers whether the PowerPoint slides could be publicly available to those interested in having access to that. And if, with the permission of the speakers, we will try to make it publicly available through appropriate means. Thank you very much. I hope to see you next year in person. Thank you very much.
Thank you all for the wonderful discussion. Before we move on to our last session, session 4, we will take a brief 10-minute break. So please take a moment of rest and return back to us at 5:40 p.m. Korean Standard Time and 9:40 a.m. Central European Time. Thank you and see you in a bit.